Hello, this is Danu, and today I'm going to review the paper International Law and Dispute over the Spratly Islands, Whither UNCLOS, written by Xavier Furtado, published on Contemporary Southeast Asia in December 1999, in volume 21, number 3, pages 386 to 404. Let's get started. So, before we dive into the journal, the Spratly Island Dispute is a territorial dispute between the 6 countries, China, Taiwan, Vietnam, Philippines, and Malaysia, and Brunei, over a group of islands in the South China Sea, as shown in Britannica. This is a photo from Britannica. So here are the Spratly Island areas, and the 6 countries are claiming sovereignty over these islands for resources, diverse economic resources, and political reasons. And this dispute is also known as the South China Sea dispute. Let's get into his journal. So, in the journal, Xavier points out his analysis first on the different claims of each countries on the Spratly Islands, such as China, seen here, and Taiwan, Vietnam, the Philippines, and Malaysia. Unfortunately, the author didn't include Brunei in his journal. After he lays out each country's claims on the Spratly Islands sovereignty, he points out his analysis on the limitations of current solution that the international community is taking to solve the dispute, which is a utilization of UNCLOS, the law of the Sea Convention by the United States, by the United Nations. Here, Oceans and Law of the Sea, United Nations. This organization provides the standards on how to regulate the oceanic boundaries among the islands, but because of the convention's vague wordings and selective interpretations or exploitations of the laws by the 6 countries to support their argument, UNCLOS is having the challenge to work as a credible convention to solve the dispute. Now, the journal cites Juno Park to provide an alternate reason why the dispute is challenging to solve, and it is displayed in page 397. The journal cites that international law can effectively resolve only disputes that are basically legal, and the Spratly dispute, with its highly complicated historical background, are political in nature and susceptible therefore to political resolutions only. In short, because the Spratly Island is a complex problem where the politics and the history of each state is incorporated with various other perspectives like economy and politics and safety and military and all the other perspectives, it is difficult to be resolved only with laws and arbitrations. Lastly, the author points out the problem with the dispute settlement process UNCLOS is taking for each state. The author states that UNCLOS has 2 forms, ITLOS, the International Tribunal for the Law of the Sea, and ICJ, the International Court of Justice, to settle disputes between the states. And these forms require the signatories to make binding decisions, meaning the states cannot edit the resolution afterwards, as displayed in page 400. However, UNCLOS grants coastal states exemptions from the binding resolution requirements. So although the signing of UNCLOS here displays that the decision may have been unavoidable for the situation, it is clear to predict that this difference of discussion rights and dispute settlement rights in UNCLOS form would, if not already, hinder further dispute settlements among the coastal and non-coastal states in Spratly dispute. So, in conclusion, the author illustrates that future methods to solve the dispute should consider how to integrate UNCLOS procedures into larger dispute resolution process and and that those methods should be specific to Asia Pacific region. And the rest of the journal is consisted of the notes that the author provided among this article. Thank you.